Ladies and gentlemen, welcome to the weekend review. We're getting everything started right now.
With that plea. So it is my understanding today that the defendant wishes to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 1, theft, a felony of the 5th degree, count 3, theft, a felony of the 5th degree, and count 5, theft from a person in a protected class, a felony of the 4th degree. Thank you.
Mr. Mulkey.
Thank you, Your Honor. That is all accurate. I discussed this matter with my client. I received all discovery in the matter. We discussed and agreed to a restitution amount as well. Your Honor, we'd ask the court to order a PSR upon acceptance of his guilty plea as outlined by the state. Thank you.
All right. Mr. Walker, how old are you?
42, Your Honor.
Okay, you can remain seated. How far did you go through school?
College, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, Your Honor.
Have you ever been diagnosed with or treated for any mental illness?
No, Your Honor.
Did you get a copy of this indictment?
Yes, Your Honor.
It's been represented to me you're going to plead guilty to count 1, theft to felony 5, count 3, theft to felony 5, and count 5, theft from a person in a protected class, a felony 4, and then the remaining counts would be dismissed at the time of sentencing. Is that your understanding?
Yes.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want to talk to Mr. Mulkey some more, let me know and I'll give you more time. Do you understand that?
Yes, Judge.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Judge.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Judge.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Judge.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you could not afford to pay for those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Judge.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Judge.
Do you have any questions about any of these rights?
No, I do not, Judge.
Do you still want to plead guilty to these charges?
Yes, Judge.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, Judge.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
Yes, Judge.
In count 1, theft is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Judge.
Count 3, theft, a felony 5, also carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Judge.
In count 5, theft from a person in a protected class is a felony 4. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, Judge.
Now, I could give you a consecutive sentence. That means one sentence after for the separate offenses. If I did that, you face a maximum prison sentence of 42 months and a maximum fine of $10,000. Do you understand that?
Yes, I do, Judge.
There will also be restitution ordered in this case, and is the agreed upon amount $12,017.49, counsel?
Yes, Your Honor, it is.
Yes, Your Honor.
All right, so you will also be ordered to pay restitution in that amount. Do you understand that?
Yes, Judge.
Any question about the penalties?
No, Judge.
All right. Do you understand that if a prison term is imposed in this case, that you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, Judge.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Judge.
If your violation of post-release control is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Judge.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes, Judge.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, Judge.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 42 months. Do you understand that?
Yes, Judge.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Judge.
Has anybody promised you what I will sentence you to in this case?
No, they have not, Judge.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
I understand that, Judge.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes, Judge.
Has he discussed everything about your case and answered all of your questions?
Yes, Judge.
Are you satisfied with the advice he has given you?
I am, Judge.
Have you been threatened or coerced in any way to plead guilty today?
No, I have not.
Are you freely, knowingly, and voluntarily entering your guilty plea?
I do, Judge.
Do you have any questions?
No, I do not, Judge.
Ms. Haranek, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that as to count 1, on or between June 8th, 2022 and September 20th, 2024 in Kirtland Lake County, Ohio, the defendant, with purpose to deprive Carrie and Patrick Gerbrocht of U.S. currency, knowingly obtained or exerted control over that property beyond the scope of the express or compliant consent of those individuals, and the value of that property was $5,000. As to count 3, the state would have proven beyond a reasonable doubt that on or between October 3rd, 2022 and September 20th, 2024 in Kirtland Lake County, Ohio, the defendant did with purpose to deprive Wendy Bach, the owner of U.S. currency, knowingly obtain or exert control over that U.S. currency beyond the scope of the express or implied consent of Wendy Bach. The value of that property was $3,077.49. And as to count 5, the state would have proven beyond a reasonable doubt that on or between December 30th, 2022 and September 20th, 2024 in Concord Township, Lake County, Ohio, the defendant did with purpose to deprive Kathy McAdams, the owner of property, specifically U.S. currency, knowingly obtained or exerted control over that U.S. currency beyond the scope of the express or implied consent of Kathy McAdams. And at the time, Ms. McAdams was 68 years of age, and the value of the property involved with Ms. McAdams was $4,500. Thank you.
All right. Mr. Mulkey, anything to add to those facts?
Nothing to add, Your Honor. Thank you.
Mr. Walker, did you hear what Ms. Haranek said the facts would show if the case went to a trial?
Yes, Judge.
And are those facts true?
Yes, Judge.
All right. What is your plea to count 1, theft, a felony 5?
Guilty, Judge.
What is your plea to count 3, theft, a felony 5?
Guilty, Judge.
And what is your plea to count 5, theft, a felony 4?
Guilty, Judge.
Mr. Mulkey? Bob, do you have a date, sentencing date?
No, Judge. Right.
Mr. Walker, is this your signature on the written plea of guilty?
It is your Judge.
Did you sign it voluntarily?
Yes, I have, Judge.
And do you want me to accept your written plea of guilty?
I do, Judge.
All right, I'll accept the written plea of guilty. Defendant was present. Mr. Mulkey advised of all of his rights, been a knowing, intelligent, voluntary waiver of those rights. He understands the nature of the charge and consequences of his guilty plea and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept his plea of guilty. Find him guilty of count 1, theft to felony 5, count 3, theft to felony 5, and count 5, theft to felony 4. I'll refer this for a pre-sentence report and victim impact statement. Sentencing will be 3/14/25 at 3 p.m. and the bond is continued. Anything else, Ms. Haranek?
No, Your Honor, thank you.
Mr. Mulkey?
Nothing, Your Honor.
All right, we're adjourned.
What's a good cell phone? 655. The longer it goes on, the worse, it gets.
Well, and you're still at 509 and a half High
Yeah.
Street or Fairport.
All right.
Seated. Ms. Haranek?
Thank you, Your Honor. We're present in the matter of State of Ohio versus Timothy Walker, case number 24-CR001140. The defendant is present in court with defense counsel Chad Mulkey. We were previously in court on January 29th, 2025, where the defendant withdrew his previously entered plea of not guilty and pled guilty to count 1, theft, a felony of the 5th degree, count 3, theft, a felony of the 5th degree, and count 5, theft from a person in a protected class, a felony of the 4th degree. The defendant was found guilty, and the court ordered a pre-sentence investigation and report and victim impact statement. The state has had the opportunity to review those reports and is prepared to proceed with sentencing. Thank you.
Mr. Mulkey?
Yes, Your Honor, we are prepared to go forward with sentencing at this
Right.
time. Thank you so much, Your Honor. My client is 43 years old. He is married. He has one child who's 22 years old. He indicates to me, Your Honor, that he receives veterans disability benefits for a number of disabilities. He served approximately 16 years in the Army. He further indicates he was honorably discharged, Your Honor. He does have incoming proceeds as a result of his disability benefits, with which he plans to use to pay the restitution owed in this case, the approximately $12,000, Your Honor. He indicates he would have no issue paying at least $1,000 a month for the next 12 months and possibly have the entirety of the restitution paid off sooner than that if needed to do so. For that reason, Your Honor, we would ask the court to consider a community control sanction in this matter, not a term of incarceration in the local jail or in the prison at this time. Your Honor, he acknowledged to me when I talked to him and as I reviewed the PSR that he should have been forthright in his dealings with these folks, these jobs that he never completed, Your Honor, and he does want to acknowledge that and make that right at this time, Your Honor. He is retired, so he's not currently working, but as I said, he does have a means with which to pay, no outstanding warrants. He doesn't have a valid license right now. He indicates he chooses not to get one. Driving makes him uncomfortable, Your Honor. And with all that being said, again, we would ask for community control, no prison time, no actual jail time on this case, and then whatever community control sanctions, of course, deemed appropriate by the court, Your Honor, including the aforementioned restitution. Thank you.
What do you have to say?
I take 100% responsibility.
No, you don't. You were telling the probation officer that you sold the business and you didn't know that they didn't follow up. So you don't take any responsibility.
I did say that, Judge.
Why did you say that?
I was wrong. It was my fault. I signed these contracts with these customers.
Who did you sell the business to?
One, and I can get you his last name. I can't pronounce it.
Okay. I don't believe you. You had contact with these people up until you refused to have contact with all these people. Over and over and over, they tried. And then you promised them you'd give them the money back, and then you just disappeared. So you didn't sell the business to Juan somebody or other, okay? You just took the money and didn't do the work. So you don't take any responsibility. I don't know what that word means in the context of a criminal case anyway, but you don't take any acknowledgement that you did anything wrong.
I did.
Okay.
It was wrong on my end. What I did was wrong, 100% wrong. I want to make it right, and I will make it right. The only thing I can do by making it right is paying them back what I took from them.
3 years ago. So what, I'm gonna believe you that you're gonna pay him back?
I swear on everything that's holy, Judge, that
Doesn't
I'm
mean
going
any,
to pay.
it doesn't mean anything to me.
If you give me the
Your
opportunity,
your
I-
word, when I read this pre-sentence report, it blares out at me that you're not to be believed with anything that you say.
If you give me the opportunity to show you that I am truthful with paying all this restitution back and anything else that I need to pay back, all I ask for is one chance. And if I mess up, which I won't, but if I do, then have your way with me, Judge.
I can do that right now.
I understand that. But I just ask.
What did you do with all this money that you stole?
I don't know, Judge.
You don't know. Why don't you know?
I don't know where it went. I had a real bad drinking problem, I had a bad gambling problem, but that's not an excuse. I don't know where it all went.
Didn't you tell her, the probation officer, you didn't have any problems? You certainly didn't have a drinking problem, right?
Not anymore.
Okay.
I don't do drugs. I don't gamble anymore.
So that's where it went, gambling.
Majority of it, gambling and drinking. Yes, Judge. If you give me the opportunity to prove to you that I will pay this back in a timely manner that you set forth.
Well, you know, isn't there more to it than just paying it back? I mean, they've been, first of all, Miss McAdams, you really took advantage of her. Okay? You knew her husband was a vet.
Yes,
You knew he had recently passed away.
that is correct.
And then you went and said you would help her any way you could. And then, boy, you really stuck it to her. You really, really took advantage of her. That's despicable.
I did, Your Honor, I did. And there's nothing I can say besides that I was completely wrong in doing that and doing it to everybody else.
No kidding. No kidding. So, beyond the monetary damage that you did to all three of these folks, what about the emotional damage you did, especially to her?
I understand.
You understand?
I broke a trusted friendship. You know, I'll never be able to regain that. I wish I could in any way whatsoever.
And then you just wouldn't respond to her. And then she put something on Facebook. And you immediately respond to that. Nice job controlling the little group chat on that stupid Facebook Kirtland thing. Nice job doing that. Part of the game. So she put something on Facebook. Then you call her. And you say to her, what the fuck is wrong with you? Did you say that to her?
I don't remember.
You don't remember. Well, my guess is you said that to her. Okay? Because there's one thing I know, okay? This is the second time, third time I've met you, right? Pre-trial, plea, and now.
Yes, Judge.
I have not met Ms. McAdams. I did read her victim impact statement. And I believe her, I don't believe you. So you said that to her.
Then I did say that to her, Judge.
You did.
I honestly, I don't remember, but I do use that language, or I did use that language quite a bit.
So you not only have, from what you're telling me, assume it's true that you had a drinking problem and you had a gambling problem. You also had a theft problem. You have
Yes.
no respect for other people's property.
Unfortunately, at the time, I wasn't thinking of it that way.
You're a grown adult, right?
Yes, Judge.
You served in the Army, right?
Yes, Judge.
Okay, you know right from wrong, right?
I do, Judge.
Okay. So don't tell me you weren't thinking of it. You thought clearly about it. And this nonsense that you were on a ventilator from COVID and you couldn't perform a job when you were in Florida. This is a big con that you started with this Facebook thing. You know, what's it called? Something Kirtland? All around Kirtland?
That is a group that,
You don't live in Kirtland,
no, I do not.
and you were the, however, you become the administrator of all around Kirtland for the sole purpose of stealing money.
I did work in Kirtland when that group was created.
Right. Were you all around Fairport too? Were you that one? Were you administrator of that?
No.
one? Okay. There's more money in Kirtland than there is in Fairport, right?
I don't know.
Yeah, you do know. Where did you grow up?
Menor?
You know goddamn well there's more money in Kirtland than there is in Fairport. So don't tell me you don't know.
Okay.
Right?
When that page was created, I was working at La Kersey Garden Center for the sole purpose of trying to advertise for them. That was the sole purpose of why that page was created at the time.
Listen to me. Don't bullshit me, okay? When somebody, I forget which victim it was, went on that Facebook page looking for suggestions for contractors, you immediately responded because you're in control of the whole thing, okay? That's why you set it up. So what's the price you should pay beyond the restitution for what you did?
To be perfectly honest with you, Judge, I would ask all the victims what they would want me to do for them, or to help the community out, or...
I already got their statements. I already know what they want. I asked you what you think I should do to you beyond the restitution.
some type of community outreach in support of less fortunate people. Giving my time up to help people in need, to help the communities, whatever they may need. The only thing I can offer.
Why would I send you out into the community when you've demonstrated you're a con man? Why would I do that? Why would I give you another field of victims to troll upon?
To give me a chance to prove that I'm a better person.
Well, you can prove, you don't need me to tell you to do something to prove you're a better person. You can prove that you're a better person by being a better person, okay? That starts with not stealing from other people. I have nothing to do with you being a better person or a worse person. I have nothing to do with that.
I would like to show everybody that I am a good person by allowing me to.
Nobody's standing in your way.
I want to prove it to myself that I'm a good person. I want to prove it to everybody that I am a good person. I made horrible mistakes, and they were very bad mistakes.
It's not a mistake, though. It's a conscious action. Those weren't mistakes. Mistakes is you meant to turn left, but you turned right, and then you had to double back to go back where you can. That's a mistake. You made conscious decisions to steal from people,
And
to take advantage of people.
I did.
It's not a mistake.
I never want to do anything like that again,
Well, then you shouldn't.
and I won't.
I hope you won't.
And I hope I can, prove to everybody that that will never occur again.
Well, there's 100% way to prove to people that will never occur again. You know what that is?
Not to do it again.
Not to do it again. This ain't rocket science we're dealing with here.
I understand, Judge. But I still need to prove to myself, to everybody, I need to. So everybody knows I'm not this horrible person that I was. I was a horrible person. Doing this to my friends, people that trusted me.
Anything else you want to say?
I mean, I can't change what I did. What I did was completely wrong. I knew what I was doing at the time, and it was wrong. The only thing I could do now is try to make everything better by paying them back, which is perfectly fine, and hopefully they can forgive me one day for being a horrible person.
Well, nobody can ever change the past. It's impossible. Okay? Now, whether they change course in the future is up to them. Okay? I'm a little skeptical of you when you give that bullshit story to the probation officer that you sold the business and you thought everything was being done, which that isn't even close. I mean, that is so, I don't know why you peddled that to her, okay? Because these people, these three people chased you and chased you and chased you, and you ignored them and dropped off the face of the earth until she put something on Facebook, Miss McAdams, and you responded to her. You didn't sell it. What? So that makes me very skeptical that you're apt to change at all.
I am, Judge. And all I ask
You can tell me that, okay, and I can say I'm skeptical, and you can tell me you're gonna change, and I can say I'm skeptical, and we can do this till noon or so. I mean, so what? Doesn't mean anything.
I can prove it to you. If you give me the opportunity, I will prove it to you.
You don't, see, that's where you're mistaken. You don't need an opportunity. I don't give opportunities. I just sit here, okay, and deal with what comes before me. You create your own opportunity.
I will make that happen. I know I can, and I know I will.
All right, have a seat.
Yes,
Veronica?
Your Honor, I believe Ms. McAdams is present today and would like to make a statement to the court prior to the state making the recommendation.
Thank you, Your Honor. I'd like to address the defendant if I can.
Sure.
Tim, before I go any further, I want to know why you hurt me. Please don't use the excuse of substance abuse, and don't lie. I have no tolerance for lying. So why did you hurt me?
I don't have a good reason for you, Kathy. I had the money, and I didn't do what I intended to do with it.
Well, you broke my heart.
I apologize with everything
You
in
were
my
at my
soul.
husband's funeral, and you promised you would help me. So, today, you'll receive what you deserve. Whatever the judge says you deserve worse. But that's not my call. The judge will determine your fate. Only you can change the direction of your life, no one else. The judge will give you the tools, but only you can use them. Tim, you need to look at the man staring back at you in the mirror and finding out if you like that person, because that person isn't very likable. You hurt me. Only you can change the person in the mirror. I'm going to give you something you haven't asked for. Of course, I want my money back. But I'm giving you my forgiveness. I'm not offering it, I'm giving it to you. And that's not easy for me to do. It's been 3 years of this, excuse the expression, bullshit. And it needs to end. But the forgiveness starts here and now, and you need to prove it to every single person in this room that you can and will change. I never want to see your name again. I don't want to see it in any court roster, nothing, ever again. Good luck to you.
Thank you.
Thank you, Your Honor. As part of the plea agreement, the state did agree to recommend community control sanctions at sentencing, and the state entered into that agreement for the sole purpose of the hope that the victims will get paid back and will get their money back. The defendant has spoken a lot about wanting the opportunity to make things right and wanting the opportunity to pay these people back. These people have been asking for their money back for 3 years. He's had 3 years to pay it back, and actually the Gerbachs, Carrie and Patrick, have a default judgment against the defendant for the money that he owes them, and he has not paid them. So that opportunity has existed. He has not paid them back. The defendant is also currently has a case pending in Cuyahoga County regarding working for a Dollar General and stealing over $10,000 for that Dollar General. And I think the theme here is he's put in a position of trust. People put their trust in him, and he repeatedly breaks that trust, and he repeatedly steals from them. Specifically, Ms. Bach as well. This affected her business and her livelihood. She was relying on the defendant so that she could make her livelihood renting out her property, and she was not able to do that because of the defendant's actions. So the state is asking for community control so the defendant can pay the full restitution amount of $12,017.49. That is not the entire amount that he took from the victims. However, one of the victims was able to repurpose some of the items that the defendant left at her home, and so she herself did the math to figure out what she wanted to be fair. She wanted to be fair to the defendant, and so she was able to figure out that about $560 worth of things she was able to use, and she is not asking for that in restitution. Altogether, the money that he took was $12,577.49. State is asking that the defendant be put on a stringent payment plan so that this money gets paid as quickly as possible. Thank you.
All right, I've reviewed the pre-sentence report. And the victim impact statements, as well as a letter on behalf of Mr. Walker. Considered all the provisions in 29, 20, and 11, 12, and 13. One of the things that really bothers me about you beyond the obvious is the fact that you minimized everything when you went over to the probation department and were interviewed over there. From what you did with regard to these 3 jobs, the alleged sale, the lack of any problems with it as it relates to drugs or alcohol, never once indicating that you had a gambling problem, because that's the obvious thing to me, jumps out at you. That's where the money went. Perhaps on your vacation in Florida too. So right up until today, you minimize what's going on here. I'm going to go along with the joint recommendation and place you on community control for 5 years. You're going to serve 180 days in a Lake County jail with credit for 2. You're to have no drugs or alcohol, and you'll be screened. You're going to pay restitution to the Gearbox in the amount of $5,098, to Ms. McAdams in the amount of $4,500, to Ms. Bach the amount of $6,769.51, and that will be payable at the rate of $1,000 per month to probation. You're going to get a drug and alcohol evaluation. You're going to follow the recommendations. You're to have no contact with the victims. You're going to complete the decision points program and follow the recommendations. You're going to get a valid driver's license. You're going to pay the cost and supervision fees. Any other terms, Ms. Randazzo?
Nothing further, Your Honor.
Do you understand the terms?
Yes, Judge.
If you don't comply with the terms, the state will file a motion to terminate your community control, and if I find you violated, you face 42 months in prison. You understand that?
Yes, Judge.
Anything else? What?
Just to clarify for the restitution
What?
amounts, I have $5,000 to the Gearbox.
5,098.
5,098.
Yeah.
4,500 to Ms. McAdams.
Right.
The amount that I had for Ms. Bach was $2,517. So can you just repeat your amount again, please?
She's got an amount of $6,769.59.
Okay.
That was
$759.
$6,769.51.
Thank you.
And that was a higher number that was reduced by whatever method she determined she got items returned.
Thank you.
Anything beyond that?
No, Your Honor.
Mr. Mulkey, anything else?
Nothing, Your Honor. Thank you.
All right, we're adjourned.
All right.
Anything on you want to give your family?
Just my code.
Just your code?
Well, I have cell phone in there.
Okay.
I mean, I'll just take my whole code.
You want me to take it? Okay, I'll take it.
All right, well, put our on your back.
You got anything on you that's illegal, anything you can't take into a jail?
No.
Go this way.
Well, that was O'Donnell. Ladies and gentlemen, we're traveling the other way across the rainbow, going all the way to Kansas, where Judge Webster had a lady who was a little bit more than disagreeable. And all of that, ladies and gentlemen, this is a compilation. This is a compilation of cases that goes back. Well, you'll see. You'll see. All of it starts right now.
No James Watts. How about Gerard Scott? Gerard Scott, are you here on Harmon? How about Derek Smith, attorney?
I'm here for Harmon, Your Honor.
Okay,
I'm just asking for a week or two extra just to go get her arrested. She keeps saying she has an attorney taking care of it. And
all right. Well, let me call that case. We're here on the record in 2022, TR 3025, State of Kansas versus Amanda Rose Harmon, Jared Regier for the state, and Gerard Scott, you are or are not here. Neither defendant, is Amanda Harmon here, neither defendant nor attorney are present, and this is a motion for judgment on bond, and the bondsman, Dante Duncan, is here. Go ahead, please, Mr. Duncan.
yeah, I'm just, we've been in contact with her and she said that she had her attorney handling the case. And then we contacted her this morning and no answer, no reply. So as soon as we get done with court, we're actually just going to go arrest her. But we're just asking for a little bit more time so you don't take judgment on us.
State's response?
Your Honor, as a preliminary matter, this appears to be a case where previously an entry of appearance with respect to Mr. Scott was filed. I am showing more recently, although I, of course, can't speak to that as I cannot speak for counsel for the defense, a motion as well as an order allowing an attorney to withdraw. The state would be requesting clarification as to whether or not there is a counsel of record at this time.
I am not showing she has counsel on this.
Amanda Rose Harmon. Summary doesn't show counsel, but when I printed out the list, Gerard Scott's name popped up for some reason. That is curious because when I print the list, it says Amanda Rose Harmon, motion, Scott, Gerard Charles, but I don't see it anywhere on the file. So why in the world did the printed copy show up with that? I do not know. All right, so defendant Gerard Scott is not on this case.
You didn't bring that to.
Motion for judgment. You're going to go out and you know where she is and you can go arrest her, counsel, or Mr. Duncan?
Yes, ma'am.
Why has she not already been arrested?
Because I was taking her word that she had counsel and was getting it taken care of.
Okay, well, December 2nd, she emailed the court to notify the court of her, quote, defamation of character by libel and slander, quote, she claimed she filed the notice of claim and notice of demand for redress, remedy, and a public apology. And this was sent even though she had failed to appear for court on November 25th, 2024. It would appear she did have access to her public record through the public portal and Zoom, as she referenced them consistently in her emails. We had back on November 25th, Attorney Gerard Scott was present, so if he's physically present, that means he represents her, and he has a duty to file a written appearance, which apparently didn't. But November 25th, 2024, defendant failed to appear, but Attorney Gerard Scott was present via Zoom, requested a competency hearing, an oral competency motion was granted, and so that's where Mr. Scott came from on this, it looks like. Even though and September 4th, defense attorney G. Scott appeared. Are you not seeing those in the notes, Jen?
I am, but on January 29th, the attorney was allowed to withdraw from the case.
Okay, January 29th, he filed a written motion apparently.
Yes.
And I approved it. Okay, thank you. Thank you very much. All right. Get her turned in.
Yeah, and I'm, Your Honor, once I book her in, I am not bonding her back out. She's staying in there, at least through our company. I'm not. There's too much going on with her and her case. Once we get her, she's staying.
All right, we're going to continue this hearing, the motion for judgment on bond. To what date? Yeah, May. Well, can we give it? What's 7 days from now? The 24th. Can we do a hearing on the 24th? Is there any way we can squeeze one in?
You can squeeze it in.
All right. We're going to continue this to March 24th, 9 a.m. And if she's in custody, we will consider letting you off that bond, sir.
All right, I will get that done for you, Your Honor.
Okay, thank you very much. We'll be
Thank
in
you.
recess.
And Your Honor.
Hello, Judge.
Good afternoon, Darren. First case on first appearance docket this afternoon, State of Kansas versus Amanda Rose Harmon, 22 TR 30/25. State appears by Butler County Attorney Darren Devaney. Matter does regularly come back before the court this day. The court does find that Ms. Harmon, you previously have been represented by Gerard Scott. Subsequently, on March 17, 2025, which would have been Monday, with Judge Webster presiding, that you failed to appear, and subsequently the case has been set over to, pardon me?
I said, I just stretched and I popped my broken shoulder. But here's the deal. I'm guilty. I'm guilty. Let's get this over with. This has gone on too long. I have a job. I need to get to my job. I have a very, very good job. And this has gone way too long. When Gerald Scott, when he fired me, he didn't tell me about court. So this is all wrong. This is not right. You guys know for a fact this has been going on too long. So I'm guilty of whatever I've done. I'm guilty. I'm guilty. I'm guilty. Punish me. Put me on work release, something, so that way I can get to my career. Okay. I'm doing good. Let me do good. Let me continue to do good, because if I go and if you guys drill me on this, and if you guys get me really good on this, then I'm going to get out and not do good. But if you guys bless me today and let me do good, let me go out and do my job, then I will do good. I will become a cop in 2 years whenever I can. I don't even care. I want to join you guys. I don't want to harm or injure you guys. I want to succeed. And I finally have a really good job. It's $30 an hour plus 25% commission. I do grant writing. I build homes, mini homes for veterans. Let me do my job, please.
Thank you, Ms. Harmon. The court does find that on 3/17/2025, this matter was set over to March 24, 2025 at 9 a.m. I do not know why you're appearing before the court today.
Okay. Okay. So what can we do today? Can we find me guilty and put me on ankle monitor?
Your Honor, there was a order for determination of competency.
I have a career. I don't want to take it to trial. If that's competency, if we take it to trial. So let's not even worry about that. It's just I'm guilty of all charges, and throw me a whole bunch more. I don't even care. I'll take everybody's charges today. But I'm guilty. That is what I am, and let's get this over with. Put me on ankle monitor. Get me back to my work, because I have a career now. I do have a career.
When was the competency
I don't know,
hearing?
because my attorney was a horrible. That's why he got fired.
Mr. Devaney, do you show that?
Looks like it was January 28th.
January 28 of 2025?
Your Honor, I'm trying to pull it up. I'm sorry. Yep, January 28, 2025. There was it's in reference back to a November 25th, 2024 hearing. That the court had ordered that the proceedings be suspended. I mean, that was still pending. And then the defendant has, apparently released her attorney.
We fired each other.
The determination by the court back on November 25th that there was that the defendant should undergo a competency evaluation.
And the reason why is because I didn't accept what he was trying to give me. He was trying to give me, after 3 years dealing with this case, you're going to try to put me on probation? What kind of lawyer are you? Why would I spend this much money on a lawyer for him to put me on probation when I should have just got a fine from the beginning? Why are we still even here about this case? That's my question. So competency, I think, who's the competent one? Definitely not my attorney. That's why he's fired. And the competency was supposed to be for...
Mr. Devaney, what do you show on status of the case? I show March 17, 2025, that this was set back over to March 24, which would be next Monday at 9 a.m.
That's for the motion for judgment on bond, Your Honor. Yeah,
Okay.
The notes from Monday, let's see here. Sorry, I'm trying to read and catch up here. It looks like the pending open action is the motion for judgment on bond, and that's what was originally scheduled for Monday. And the defendant failed to appear for the motion for judgment on bond. But technically, that motion for judgment on bond was more in relation to the bondsman's requirement to be here and answer with regard to the defendant's appearance.
Okay. It would appear it's very convoluted, the trial docket notes, but it appears that Gerard Scott last appeared on November 25th. Defense requested a competency hearing, oral competency motion granted. Then there was a bond forfeiture bench warrant, no bond hold established, ordered at that time by someone. Has there ever been a competency hearing scheduled?
No, we haven't had the evaluation done, and there's no hearing beyond that as of yet. That journal entry was filed back in January 28th. It looks like, Judge. That would start the process towards evaluation of competency, but
if I'll file guilty, if I'm guilty, we don't need to do none of that. You guys not understand the law? I mean, come on. This is ridiculous. We've been doing this since September of 2022, you guys. This is ridiculous. I'm guilty. That's what I am. Put me on ankle monitor so I can go work. My boss is Dr. Judge Zavinia. He's waiting for me to start work. I help a lot of people. It's called Med 5. We have a $2.6 billion patent. We're helping humanity. So if y'all's got vaccinated, CDC says within 50% of you that's got the Pfizer vaccination is going to die within this year. Look at the website. Look at the CDC website. Well, we have a vitamin that's going to help that. Okay. And I've been build many homes for veterans. You guys got to let me get to my work. I don't drive no more. I won't. I'm leaving the state the second you guys are done with me. So kick me out of the state. Just kick me out of the state and I'll never come back and we don't even ever have to deal with each other. Can we do that? That would be great.
Thank you, Ms. Harmon. And Mr. Devaney, what would the state propose and request how the court to proceed today would be?
Here's, I mean, obviously the issue here is that there was an oral motion by counsel that's no longer appropriate or on the case. The court did order that competency needs to be evaluated. However, I would say I don't have independent knowledge of Ms. Harmon's competency issues. If the court determines if you're comfortable proceeding today with, and I'll start from, if she wants to enter a plea today, she could do so. As I have no independent knowledge, I guess, of any need for a competency evaluation. She'd have to waive counsel, obviously, for that to go into effect. The concern the state would have if we did that is that there's this pending order for competency that's already been ruled on by the court. And I want to make sure that we don't have a basis to withdraw a plea later down the road.
Right, true.
The other option is we proceed with the orders of competency and get that evaluated prior to a plea being entered. That obviously would be a longer setting, in which case we'd need to set a bond here today and continue out the case.
Let's just get it over with.
There's still the motion for judgment on bond, which has been now reset to looks like Monday's date on the 24th. So that's outside of really what we're talking about as far as the content of progress on the case. The only thing I'll say with regard to that is that the bondsman that she had has stated that he's no longer willing to keep her on bond. So if we continue with the competency evaluation process on this case, she's going to have to find a new bondsman on this matter. Procedurally, going through the case, it is an older case. This is a case that has gone through, well, it's been drug on for a long time. But that's really been at the hand of the defendant.
I know.
And so now at the 11th hour, we want to hurry everything along. And I mean, it's I don't know that I'm necessarily motivated to rush this case through today to get this through unless the court has assurance that we are waiving the competency evaluation and that there is somehow a basis for that.
Well, I'm sorry, Mr. Devaney, but from my understanding,
Ms. Harmon is also not the person that determines whether or not the competency evaluation should or should not be done. It's for
right. But I read the paperwork, and the paperwork to me read that because the attorney and me have a discrepancy on my cases was the competency purposes, because he sent me the file, and that's when I found out, and that's when I called the jail, or I called the district courts. The second I got that file was what, 2 days ago? So I didn't know about none of this. So, but I just wanted to make it clear, if I do plead out, that competency doesn't have anything to do with this part. It has everything to do with me and my attorney having the discrepancy on the court, on the cases themselves. Because for one, I wasn't habitual. For two, you know, all in all, but yes, from the beginning, I should have just pleaded whatever. So I'm all about pleading because I gotta get my life back. If I don't get my life back, I'm not gonna even try anymore. I'm gonna just give up. But I have a chance in life right now. In my life, I have a really good career. I mean, $30 an hour, 25% commission. Who hears of that anymore? It's unheard of anymore. And this guy's giving me a chance. He's giving me a chance. I got my own apartment. I got my own, you know, he's going to drive me around. I don't have to worry about driving no more. Like, this is the most beautiful freaking job I've ever had. And I'm going to lose it because of a September 22 case. Now, you guys would be seriously just not okay with life for anybody. You guys are not here for this, we the people. If you guys want to destroy me on this when I have a career going for me right now.
Thank you, Ms. Harmon. Mr. Devaney, who was the judge that ordered the competency hearing?
All right, that would have been that November 25th hearing. And I believe that was in front of Judge Webster, Your Honor.
Yeah. Okay. Miss Harmon.
Yes, sir.
It's been brought to my attention, and in review of the trial docket notes, and Mr. Devaney has confirmed what I have read. Judge Webster, she ordered a competency evaluation, a competency hearing, and it was granted. Defense requested competency hearing, oral competency motion granted, and subsequently that was to be back before Judge Webster.
Well, can we recuse her?
No. I'm going to expedite your case as best the court is able
Thank you.
to Judge Webster's next hearing date. Her next hearing date is next Monday, and that would be on March 24. Monday, March 24, before Judge Webster. And Judge Webster, if she wishes to withdraw the order for competency hearing and for you to proceed at that time, waiving counsel and entering a plea, that's fine. But as I find the case currently, there's been an order for competency hearing with that motion being granted.
Yeah.
So the court expedites this back to Judge Webster next Monday, 9 a.m. on her docket.
That's understandable.
And anything further, Mr. Devaney?
No, Your Honor, and again, I just pointed to the court. That's already set. That court date was already set with regard to the motion for judgment on bond, so we can kind of look at everything, I guess, globally with regard to this case
Well,
on that date, which would be Monday morning at 9 o'clock.
all right, bet.
Sounds good.
Yeah, that sounds good. Have a good day,
Okay.
guys.
All right, you too. Court's in recess.
All right, let's check at the jail. Is that a Mr. Patterson client as well?
This is Miss Harmon.
Miss Harmon?
No, she does not have Patterson.
Okay, let's take her up. We are on the record in 2022 TR 3025, State of Kansas versus Amanda Rose Harmon. Jared Regier appearing for the state, the defendant, Amanda Rose Harmon, appearing in person via Zoom, in custody and pro se on the charges driving while habitual violator and driving without proof of insurance. We have quite a bit of history, including a couple of 3 failures to appear at least. March 19th, 2025, the defendant appeared before Judge Hart. She said she had fired her attorney, Gerard Scott, and the court did not appoint a new attorney. So what are you doing about an attorney, Miss Harmon? Are you hiring another one if you've discharged Mr. Scott?
Can I speak now?
Please do.
Okay. I would like to be plea out or kick me out of Kansas. Those are my 2 options today. Because this has been going on since September 22. Like you said, we got a lot of history. Let's just get this over with. It's ridiculous. I have a career now, Miss Webster. I have a lot going on for me, Miss Webster. This is the first time in my life that I'm not on any substance. I have a career going on for me. This is my only, like, this is a lot, $30 an hour plus 25% commission. It's unprecedented to have a career. I do grant writing. That's all I'm going to say today. And so you guys have at it. That's all I'm saying.
Well, I hope you plan to answer a few questions because I have some. First of all, how old are you?
48.
You're 48, and this is the first time you're off of substances?
No, I've been off for 4 years before that. I'm just saying this is the first time I've had a career opportunity. And I'm finally off substances.
And what is this career? You said you write grants. What's your career?
Grant writing.
And who do you do that for?
For Judge Zavinia. Dr. Zavinia.
Was it judge, doctor, or both?
Yes, both.
Okay, judge, who's a doctor.
Here's his number. His phone number is 702-326. So I'm saying, kick me out of Kansas, kick me
Okay.
out of Kansas.
The
out,
judge is
out.
located, hang on, the judge is located in the state of Vegas?
Yes, no, Las Vegas, Nevada.
All right, that I.
Work from home, but I have an apartment there. I'm ready to go. I got a plane ticket already. I'm ready to get this case over with, whatever. If we need to transfer it, go ahead and put me on probation. I don't care.
Okay, well, slow down a bit. All right, so are you?
I need to get back to work. I got kids to feed. I got a house.
Hold on. Attorney Gerard Scott, it looks like was allowed to withdraw, maybe. We had a competency issue going on. Did you ever go in and submit to the evaluation?
He did that this morning.
Okay, you had a competency evaluation this morning.
Correct.
So we'll probably be getting some reports from the evaluator before long. And on the issue of the attorney, and we've got a lot of history on this case. But it sounds like you can afford to hire an attorney with this.
I can't work because you keep arresting me, Miss Webster. How can I work if I'm always in jail, Miss Webster? That's my question. My question is, how can I afford anything anymore? And how can I ever get anywhere in life if you won't stop? You got to stop abusing me. You got to stop.
Well, ma'am, you have to come to court.
You have to stop.
You have to come to court. You understand that? You have to stop missing court.
Yes, I do understand, Miss Webster. Thank you.
You're welcome.
Yes.
Okay. All right. Without me having to count, do you show how many failures to appear? Do you have that in your notes? I don't, there are so many.
Your Honor, I will need 1 moment, please.
Yeah, I was just hoping maybe you'd made a note from one of the hearings. Yeah, because
a notebook here if we need to give them a notebook somehow.
No, we don't.
All my failures to appears.
Yeah,
I got ink at home if they need.
Do you know how many you've had?
It's not about that. You guys are trickery, is all I'm saying, and you guys need to stop.
Okay, well, how
I got a career for the first time in my life. I've got a really good career. This is getting ridiculous.
All right. So, are you going to represent yourself then?
I guess.
Well, it's up to you.
Yes, I'll represent myself.
Did you apply for court appointed since you saw the last judge?
I don't know, because there's, like I said, there's too much history behind all this, you guys. So I represent myself today. And let's plead out whatever we need to do to get this over with.
Well, I'm going to need to see the evaluation results. I ordered that competency evaluation. It looks like motion and order were filed January 28th.
Nobody let me know. Just so precious.
January 29th of 25 was when the court allowed the attorney to withdraw. Now, for your information, there was on March 19th of 25 an amended complaint and information filed. So officially, you're looking now at count 1, driving while habitual violator, a Class A non-person misdemeanor. The state did on March 19th dismiss the no proof of insurance. So apparently, they have gotten proof of insurance. The only charge you're looking at right now is driving while an habitual violator. But I'm not in a position to entertain a plea of any type from you until I get the results of your competency evaluation.
It's fine, let's just get this over with.
Well, I understand that, but Deputy, did they give you any idea how long it might be on the evaluation? If in fact she had one this morning, did she have an evaluation for competency?
She did have a visit this morning. I'm not sure who it was with. I have no recommendation on time as far as how long they're taking with anything.
It sounds like you're not even sure that it was a competency evaluation as opposed to maybe a therapy session.
It was a competency and she was from the courts. They should have that by now.
It was some kind of pro visit, but I don't know who it was with, ma'am.
Okay. Mr. Regier, do you know anything about that?
I do not, Your Honor. It does appear that previously, on motion of the defendant's attorney at the time, if my memory is correct, that the court did enter an order for determination of competency. It looks like, that was filed with the court back in January of 2025. I was not the prosecuting attorney at the most recent hearing before Judge Hart, although after conferring with the county attorney, the state has its own concerns as it relates to KSA 223302, which I believe that order was issued under. So the state the state respectfully submits that the court should maintain its prior orders on that particular issue. In response to the court's inquiry, or rather earlier inquiry, this is a case that appears to have at least 6 prior failures to appear. It would appear that perhaps most notably, based off my notes, the matter was set for bench trial back in March of 2023, at which time the defendant excused herself from the bench trial. So the state does respectfully maintain that the court's prior orders, both concerning the competency order and any orders concerning bond, should be maintained.
All right, right now she's setting on a.
Ma'am,
Yes,
it
sir.
was a competency hearing this morning.
Bless you.
Good, good. Thank you. Thank you. All right. Looks like, and right now it looks like she's detained on a no bond hold, officer. I'm going to order that be maintained. I'm also going to appoint Attorney Darren Patterson to.
All right, thank you. Have a good day.
And I'm going to note that she got up and left in the middle of the proceedings again. So we're going to reconvene May 12th at 9 a.m. No bond hold. Darren Patterson appointed. Clerk, please let Darren know that she's being held on a no bond hold with awaiting a competency evaluation, with their next hearing being May 12th, 9 a.m. in case he thinks we need to visit anything before then. But again, we need to let him know that she's in there on that no bond hold. Anything else, Mr. Regier?
Not on this matter, Your Honor.
All right, thank you. Then we'll be in recess. Mr. Case, remind me who you're here for?
I am here for a few. One was Harmon. So when last week Dante spoke with you, we left and went to her house. We went and arrested her and booked her in on that one. So, but wanted to make sure we were good on that one, and which looks like we were, because there wasn't mentioned on that one.
Okay.
Now,
you were here on the one that we just had?
correct.
Good for bringing her in. Okay.
And Your Honor,
Yes.
may one additional matter, if the court is prepared to go back on the record in the
Yes,
absence
we
of the
need to.
defendant.
Back on the record in 2022 TR 3025, State of Kansas versus Amanda Rose Harmon. Jared Regier still here for the state. The defendant still absent after having left in the middle of towards the tail end of the hearing. Noting that her bail bondsman Tyson Case is present, and having told the court just now that he did. Did you go pick her up or just tell her to turn herself in?
We had to set her up and get her picked up. So yeah,
okay.
She was on her way to live on a commune in Las Vegas. She was going to live off the land.
I see. Thank you for that additional information. Darren Patterson, if you're listening, you've just been appointed to her. She did have Gerard Scott, but first, I think he was privately retained, but she dismissed him, and she just had a competency evaluation this morning that was ordered in January before she disappeared. So you're wanting relieved from the bond, Mr. Case?
Yes, please.
All right, Mr. Regier, your position?
Yes, Your Honor. Given that the defendant had previously appeared, albeit not for an entire hearing in this matter, it would appear that a motion for judgment on bond was filed with the court on January 27th, 2025. would appear that the court is the state's understanding that the court had previously appointed Mr. Patterson, who does appear on at least at this juncture. If the court is satisfied in all other respects, and assuming this is the appropriate procedural time to do this under the circumstances, the state would move to withdraw the motion for judgment on bond.
Motion, I'm gonna let the bondsman off the hook, but she's gonna need to reinstate that bond since he doesn't want to be on it anymore. He's turned her back in, so she'll have to find someone else to post that bond. I've got her held. Well, wait, I've got her held on a no bond hold, so he couldn't.
Your Honor, that is the state's understanding of the court's orders when this matter was previously on the docket today.
Pardon me, Your Honor.
Yes.
And I was in a breakout room, but I just popped back in. Did the court appoint me to Amanda Harmon?
I did.
And is there already an order for the competency to be done?
Yes, Mr. Scott, I think, asked for that months ago, and
Okay.
it's a 2022 case. She's had 6 failures to appear.
And when has it now been reset to?
May 12th at 9 a.m.
If the competency evaluation gets completed and we have a written report, would it be right if I contact court counsel and the clerk to reset that sooner?
Yes, I would appreciate you doing that.
Okay, thank you.
And as I said, yeah, she's being held without bond. Mr. Case has just been released of his obligation. And May 12th, 9 a.m. She told me that she is working for a judge doctor in Las Vegas, doing grant underwriting as a career, that I think she said she is substance abuse free at 48 years old. And she gave me a phone number for this doctor of 702-326.
A decade or two, so I'm very familiar.
I have no idea about that.
I would watch the first appearances.
All right.
I've also known Amanda Harmon for, probably a decade or two, so I'm very familiar with her.
All right, very good. Sounds like that case is under control then. Anything further, Mr. Regier?
Your Honor, is the court finding that the motion for judgment on bond is withdrawn in this matter?
It is so to reflect.
State has nothing further at this time, Your
All
Honor.
right, thank you.
From Webster back to Michigan. Well, I guess that would be from Kansas back to Michigan. We're crossing back over the rainbow, ladies and gentlemen. We're going to visit Judge Shackelford. He had a couple of interesting ones. Let's see what happens. All that's starting right now.
All right, I see Mr. Phelps is back out. I'm trying to get, oh wait, we have ASM Properties back out. We have Mr. Ruark here. This is 2501-0741 ASM Properties versus Blair Bailey and Sterling Phelps. Counsel?
Ron Ruark for the plaintiff, Your Honor.
Mr. Phelps, can you tell me your first and last name?
Sterling Phelps, P-H-E-L-P-S. Sterling
All
is
right,
regular spelling, S-T-E-R-L-I-N-G.
Thank you, sir. All right, so we've had, you've had an opportunity to meet with Lakeshore Legal. It's my understanding that you did not qualify for representation through them. You've also had a chance to speak with Mr. Ruark at this point. And then and here we are. Counsel?
Your Honor, I think we need a hearing date. There's no resolution today, and I don't see a possibility of a resolution today.
All right, we'll come back for 10/25, so April 10th of 2025 at 10:30 a.m. Are we having a full-on hearing? Is there a defense? Is this something we need to do in person?
Yeah, I don't think we need to do it in person, but at this point, we're talking about having a hearing, a full hearing, yes.
All right, then we're going to do it in person. I mean, if there are going to be exhibits, listen, wait, let me talk. If there are going to be exhibits, I don't know anything about it. I don't know if there's a defense, if he's alleging that there's something wrong with the property. If there are going to be things I need to see and testimony that needs to be taken.
Your Honor, there will be, so maybe we should appear in person. I agree.
We're doing it in person, okay? Mr. I'm sorry, at ASM Property, sir, I don't have your name. What is it you needed to say?
Yes, Your Honor. My question is, I rented the property to Blair Bailey, and I don't even know why Sterling Phelps is living there from day one. Blair Bailey doesn't answer my phone. She doesn't answer my texts or emails. Every time we've reached out, he's living there. He claims to be Blair Bailey's father. I don't even know. Blair Bailey.
Where's Blair Bailey, Mr. Phelps? Where's Blair Bailey?
She is a traveling phlebotomist. She was here days ago. She was just here. So he is making this up. Me and him shook hands and said that I would take over this lease on this property and that I would give him my information the first weeks of the new year.
Okay. Miss Bailey needs to appear for court on 4/10 at 10:30 a.m. She's on the lease.
Right.
She
Okay.
got to court, Mr. Phelps. If not, they can seek a default against her. But the second mailing was not sent, so I mean the second mailing from the court was not requested, it was not sent. I don't see that she was personally served or otherwise served. So she's not in default today because she's not been served to be here through alternate service or otherwise. So we'll set a hearing for 4/10/25 at 10:30 a.m. in person, and we'll have a hearing on that date. All parties are to be present.
And that's 10:30, Your Honor?
10:30 a.m. in person.
Got it. Thanks, Your Honor.
Your Honor, if I may address the court.
Yes.
10 days ago or so, I gave your clerk, her name is Jasmine, $50 to have a jury trial set, and she didn't, for some reason or another, the legal advice person just a minute ago said she didn't see it, but
I see a jury demand. I mean, we're going to have a hearing, and then if we need a trial in front of a jury, but here's the problem. Mr. Phelps, I mean, they've listed you as a defendant, but you're not, is he in the lease as a resident or anything?
No, Your Honor.
Or an occupant?
No.
I don't think he's listed at all, Your Honor.
So is he being asked to, I mean, do you need to amend your paperwork?
Do I need to amend, Your Honor?
I'm just, if he's not there under a lease, he's not there under a lease.
That's correct.
So is this a termination of tenancy case for him?
No, we've filed it as a demand for possession. Because there's $4,700 owed under the lease. So our argument.
We're doing a jury trial on this. He's filed a jury demand and you've listed him as a defendant. If we're doing a jury demand, this date's going to be, I'm gonna have to talk to even try and find a jury date. I have criminal jury cases every Friday. And here's what I can't have. I can't have Mr. Phelps and Miss Bailey continuing to live in the property long-term and not paying rent. But I also can't get a jury here on a landlord-tenant docket in the middle of a landlord-tenant docket.
Your Honor, I would ask if we move to a jury trial that he be ordered to pay at least 1 month's rent into court escrow.
I agree.
Or maybe ongoing rent that he owes in escrow, because there is no reason. First of all, he shouldn't even be there. He's blocking and tackling. I believe this is fraudulent because that lady is out there. We should look at his record. He's probably constantly doing this to other landlords.
Look, I don't listen. I don't have, I'm not gonna start looking at his record, but listen, Mr. Phelps, you have to put 1 month's rent in escrow at the court.
Arif, tell the court how much the 1 month rent would be.
Yeah, it's 1625.
1625, 1 month's rent needs to go into escrow at the court. So you need to come into the court by Tuesday.
I would need that to be by next Friday, Your Honor.
You have to pay ongoing rent into that account too.
Thank
So
you,
if I
Mike.
give you until April 4th, you're gonna have to also pay, you also have to pay this rent for April now.
Yeah, February, he has got rent
But that's
unpaid since
assuming-
February,
That-
actually
What's that?
since January.
But I can't, my court recorder cannot take you down both at the same time. Mr. Phelps, what were you saying?
That's assuming that after I present my evidence, that I would owe half of this, even any of this.
Well,
That's
you're
why
not
I'm
gonna-
getting it.
look it.
That's why I'm
What is
asking
your
for a jury
evidence,
trial.
sir? What is your defense?
We paid to be somewhere else for 41 days, Your Honor. And I also paid a plumber to come in here before he ever attempted to have a plumber come in here. To come into this building. The reason I couldn't pay this man is because I took over. Say again, ma'am. I'm sorry.
I'm taking a 3-minute recess because I've had it and I need a minute.
Mm-hmm.
Arif, are you still there?
Yeah, I'm here.
Let me do the talking.
Sure. Yeah, I mean, Ron, just so you know, since January, there's past due rent.
That may be true. We're talking right now about escrow payments.
Yep.
The court's going to make him pay escrow for March and April next month, so if he wants to continue with the case. But let me talk to the judge.
Sure.
I mean, she's that close to terminating the hearing. Arif, when was the plumber there that you?
So I have all the proof.
I understand.
Blair
that.
called me. Yeah, Blair called me, and the very
Arif, my
next day she
question
said,
is, when was the plumber there?
yeah, I'll give you the date.
Send me the receipts and everything.
Yeah.
Send me the
We
canceled
paid
check.
$6,000 to the plumber. We have the
Send me-
receipt, we have everything.
You send me the invoice and receipt, and send me the proof of the payment itself, if it was a canceled check or whatever.
Yeah.
All right.
As soon as we were made aware, we took care of it. So this 41 day stuff, I will show you evidence of all the texts with her
Okay.
and with him.
I hear you. Send me the stuff.
Yep. And I'll send you all the receipts we paid the plumber too.
Thank you.
I'm gonna make it crystal clear to all of you before I ask you anything. The next person who talks over another person, especially me, is gonna pay $100 for direct contempt. And then the next person who talks over, we can sit here all day and you guys can both owe $2,000 in contempt by the time we're done. Answer my questions. Mr. Phelps, are you telling the court that you had to move out of the house for a prolonged period of time?
Yes.
For what reason? What is your allegation?
There were 3 inches or so of water, sewage water, not to mention, on the floor throughout the whole home. The sink and the both sinks, the double sink and the washroom sink and toilet, all backed up. And
okay. All right. Next question. Did you contact your landlord about that? Or did your daughter contact?
Yes, she contacted him about it, yes.
Did anyone come out on the landlord's behalf to look at the problem and fix the problem?
Not originally.
Okay. Did you have someone come out originally?
Yes, TI Hardware and Sewage, yes.
Did you have to pay a bill for that?
Yes, I have the receipt.
How much?
Paid. $275. $275. They snaked and stuck a camera in the system.
Okay, why did you have to move out for 41 days for that? What's
There
the
were
out?
because my daughter said that he wasn't staying in contact with her, and he didn't feel as though the plumber that okay, let me back up just a second. The guy that he had came out and said, hey, this guy thinks you guys tore up his garbage disposer. And he laughed and he said, this guy does
All right,
this
I
stuff.
don't need all that. See, this is the problem. I need a direct answer. Was it because the house was too damaged to live in for 41 days?
Yes, there was sewage water throughout the home, throughout the complete home. Yes.
How long has it been since that's been cleared up?
Around, it was a holiday. It was either Thanksgiving or Christmas. He actually
So
had
why
them
hasn't
come in
any rent been paid since then?
because I had a problem with all the money that I spent for us to be somewhere else, and I let him know, hey, I'm going to work with you. I'm going to try to get this thing done. That's when we shook hands.
But now it's the end of March and you've not paid a penny.
Well, a month ago or so, we had an argument in which I didn't think there was anything that we could do.
Mr. Phelps, you think you could just live there for free forever?
No, he said, no, ma'am. He said that he was getting the court involved and that the court would decide. And that's what
All
I
right,
agreed
well, I'll
with him.
decide. All right, nobody talk. I'm deciding. You have until April 4th to submit 1625 to the court for escrow. And then every week thereafter, while this case is pending, you have to submit $377 per week.
Okay.
And that money is not necessarily going to him. That money may be returned to you based on my ruling or the jury's ruling, but I'm not going to have, when there's over 3,000 due and owing, it sounds like you have a defense, but I'm not just going to have money accruing on this. And by the time we get a jury trial date, you owe, there's a claim for $10,000. Like, that's not happening. 1625 by April 4th. I'm giving you a few extra days for your paycheck, and thereafter you're to pay $377 every Friday at the court for the escrow account. And then at the end, I'll decide who gets what. Are we clear? Does everybody understand my ruling?
Understood, Your Honor.
All right, and Mr. Phelps and Mr. Ruark, I am going to have to find a day for this jury trial. And I want you to understand that we don't have a lot of jury trial dates. So I'm hopeful that both of you will make the date work. And I have a full expectation that Blair Bailey will be present at the jury trial. Everybody's going to be here, because if I call in residents from our community to sit on a jury trial, we're going.
Understood.
So I will get you a jury trial date. I'll take it down to my civil clerk and we'll figure out a date, and I'll try and get it done within the next 30 to 40 days. But that's the reality of a jury trial. I need to find a day.
Understood, Your Honor. I have one question, Your Honor.
Yes?
If the payments into escrow are not made, what will the penalty be?
We'll have an immediate hearing on it.
Thank you, Your Honor.
And if the payments aren't made, Mr. Ruark, I don't have time to go downstairs and ask every Friday if the payments aren't made. But if they're not made, I want you to file an emergency motion. It can be 3 sentences long, and we'll get you on the docket immediately, and we'll figure it out then.
Understood.
All right, everyone, have a good day.
Thanks, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, Detective Oliver, are you here? Oh, they're the same person. Okay. This is 822-470-7031. You want your number? It's 245-060. The other one is 241-7765. The People versus Ryan Elizabeth Parks. Detective, do you solemnly, you have your right hand raised. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Can you state your name for the record?
Detective Corporal Matthew Oliver of the City Police Department. Excuse me.
Have you read the 2 type complaints that were filed with the court?
Yes, Your Honor.
Are the facts stated in them true to the best of your knowledge and belief?
Yes, Your Honor.
Okay, let's start with the 24560, the 224 event. Can you state the facts that support the issuance of the arrest warrant?
Yes, Your Honor. On February 24th, 2024, at approximately 1 p.m., Corporal Cates was dispatched to 9450 Catherine on a reported vehicle theft. Upon arriving on scene, Corporal Cates spoke with Miss Donna Bradley. Miss Bradley advised that her granddaughter, Miss Ryan Parks, arrived at the residence unexpected and was allowed into the residence. Once inside, Parks grabbed her purse and keys. Bradley attempted to stop her, but Parks was able to overpower her and flee the residence with her vehicle keys. Parks then took her 2017 Chrysler Pacifica from the driveway and fled the scene. Parks had never had possession of the vehicle, was never allowed to drive the vehicle, and was never permitted to take the vehicle from the location. On February 25th, 2024, Bradley's vehicle was recovered by Van Buren Police Department while being driven by her grandson. The grandson advised that he had recovered the vehicle from Ryan Parks' father, who wanted to return it to Miss Bradley.
Okay, did you sign the complaint before you sent it over to the court?
Yes, Your Honor.
All right, let the record indicate I find probable cause to believe the accused committed the alleged offense and I'll therefore issue the warrant. She in custody?
Your Honor, she's in Oakland County facing a slew of charges. So I think that's why we're trying to get these sworn into.
All right, and then this is 2417765, alleged data incident, July 2nd, 2024. Can you state the facts that support the issuance of the arrest warrant?
Yes, Your Honor. On July 2nd at approximately 7:25 in the morning, Officer Hill was dispatched to 9450 Catherine on a reported vehicle theft. Upon arriving on scene, Officer Hill spoke with Miss Donna Bradley. Miss Bradley advised that her granddaughter, Ryan Elizabeth Parks, was sleeping in the backyard as she was not allowed in the residence and she was homeless. At approximately 6:55 in the morning, Miss Bradley let her dog into the backyard to use the restroom and left the rear sliding door unlocked. After a few minutes, Parks entered the back door and stole her purse and keys, which were sitting on the table. The purse contained her Michigan driver's license, credit cards, and miscellaneous cash. Parks was never given permission to drive the vehicle or use the vehicle. On July 5th, Bradley's vehicle was recovered by the Hazel Park Police Department after a vehicle pursuit. During the pursuit, Parks was driving the vehicle and was arrested at the conclusion of the pursuit. Officers conducted an inventory search of the vehicle after the pursuit and located Bradley's stolen purse with the aforementioned contents inside of it, inside the vehicle.
Okay, did you sign the complaint before you sent it over?
Yes, Your Honor.
Let the record indicate I find probable cause to believe the accused committed the alleged offense and I'll therefore issue the warrant.
Thank you, Your Honor.
All right, thank you, Detective. Okay, I have Taylor PD here. Thank you. Okay, who are we going to see?
Benjamin Racco.
All right, Mr. Racco, can you hear me okay?
Yes, I can.
All right, this is 250-990, 250-901, 202421, and 241333, and 241334.
Afternoon, Your Honor. Jeffrey Fant on behalf of Mr. Rack, away formal reading, stand mute, requesting any warrants be recalled.
All right, the warrants will be recalled on our plea of not guilty on your client's behalf. Sign the request for a court-appointed attorney. Mr. Racco, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, I did.
Did you understand your rights?
Yes.
And did you give Mr. Fanto permission to sign your name on that form?
I did.
Okay, I've also signed the request for discovery on the 0900 case.
Thank you.
As to bond.
Judge, his old cases, the 2020 driving case, and that was the world of COVID, so things were a little upside down. 2024, he was in custody at the time he was supposed to be at this court. He served 90 days Woodhaven, which is also reflective of the only hold that he has, which is Brownstown. It's a weird number. It's 1581, which implies that I think it's just money that he owes there. He said he did jail for that, but he owes money. And so just because it's an odd number, that's my best guess. So I would ask that the court grant a personal bond.
His criminal history dates back to 1979.
The heavy stuff stopped in 03, Judge.
I mean, my concern is this. I understand COVID happened. He wasn't arraigned on these until 2024. He was arraigned. He was given a $300 personal bond on the controlled substance, the driving while license revoked, the other driving while license revoked. All three of those old charges he was arraigned on in 2024, and he never came back to court. So we can't blame COVID for that. He just doesn't come to court.
Well, again, no, when he was arraigned and he was supposed to come back, that's when he ended up doing 90 days in Woodhaven.
Why didn't you come back after that?
He has some difficult family issues, Judge.
I mean, it's on the driving while license revoked 1334.
And he is on disability, Judge.
Okay, on that, I mean, he can have, I mean, I'm not even worried about that. When he can have a PR bond on 1334, $1,000 PR bond. On the other driving while license revoked, he has a $1,000 PR bond.
He owes money on civil infractions, but we can deal with that when we come back.
Right. We still have a larceny from a motor vehicle.
Good report, Judge. Without saying a whole lot, I don't see any larceny.
Okay. On the 250900, he has $1,000, 10% bond. On the possession of controlled substance case, he has $1,000 cash bond. On the interfering with police case, he has $1,000 cash bond.
We set these for next week, Judge, because he's not going to.
These are on Judge Slavin's docket. I'll make a note for the clerks downstairs to set as soon as possible.
Did you mark the file medical? Please.
I will. All right, I've written on the form for the clerks downstairs to give you a court date as soon as possible, Mr. Retro, and also to mark file medical. So we'll get you in hopefully next week.
Thank you.
Appreciate it. Thank you.
Okay, who are we going to see next?
It's gonna be, Arthur Arndt.
That's just civil infraction. They're each pending charges.
Oh.
So it's just,
Mr. Arndt, can you come on up?
Excuse me?
All right, this is 20TA10756C, 20TA16893B. The People versus Arthur Arndt.
afternoon, Your Honor. Jeffrey Tanto on behalf of Mr. Arndt, just asked for warrants to be recalled. These are two civil infractions. He owes a total of $840. He's having some significant financial issues. He's having some significant health issues. We would ask a $10 a month starting in 60 days. He just saw a doctor for his disability application, and hopes to get some news on that.
All right, I'll give him a $10 a month payment plan, sir, that you make those payments so you stay out of warrant status.
That would start in 60 days.
Thank you,
Starts, 1 second, it's March 27, April 27. Starts May 27th.
Thank you, Judge.
All right, you're all set, sir. We have more in the,
Nothing else in custody.
okay. All right, officer, thank you.
Thank you. Have a good day.
And from Shackleford, we go to where is it? I forget. We're going to Simpson. Where's Simpson at? Washtenaw County, of course. Of course, it's Washtenaw County. That's exactly where it's always been. The 14A. And ladies and gentlemen, starting right now.
Carla Green versus Dustin Mickle. And Antoinette Mickle. Yeah. All right. You guys are on the wrong side, but don't worry.
Oh.
All right.
Good job.
Your name? And Dustin. And
My wife, Antoinette.
okay, she can introduce herself. I don't know why. Got it. All right.
Sorry.
Okay. All right. Where are you folks on this case?
All right, well, I did speak to legal services as you requested, and they're not entirely, they don't know if they're going to fully take the case on, but they do want to do some investigating about the housing voucher being taken like that.
Yeah.
There must be some type of something illegal or something that happened, because they can't just do that, but they were asking for 2 weeks.
And so, Ms. Green, so that you understand, that was when I was sort of hesitating the last time. It's because it's unusual that all of a sudden their voucher goes away, right? And I'm not sure why that was. And I don't know if you know. You do?
Yeah, so I working with them in October the 24th, she sent out an email saying that they're not no longer with the state giving those vouchers out anymore. And so we showed them proof that we filled out the paperwork. And Mr. Nichols, me and him worked hand in hand. I kept on saying, I heard something from Section 8, I heard something from Section 8. Well, they stated, Hugh, the director of the company, stated that their Section 8 just said they closed the vouchers. just like that. And so in October, they knew they had to contact legal aid. It's in writing. And so I don't know. I kept on telling them, y'all got to do something, because Tracy even told them to contact legal aid back in October.
Tracy,
they worker.
okay,
They was in the homeless shelter
Gotcha.
for 2 years. But 2 years was up this February, even though last year it was 2 months. Last year the lease was up because they already had stayed a year. This made the second year, so the lease went to month. So in October, we was trying to work this out way in October, and she had just had her baby, and so I knew that he worked real hard, and it was so hard for him to delegate what he had going on. And so now we're here. I gave a 30-day notice in January.
No, I see.
And I just
Okay.
believe we would choose my please.
No, I know. And so where are you guys in reference to moving?
Sir, we have put in at least 24 applications. And the housing size that we need, they're wanting me to pay, I can pay, $1,600 to $2,000, but they want me to make 3 times the rent. They want my credit score to be a 675. So they keep denying me. And the places that will accept me, I don't have Section 8. So they don't even want to deal with me, even though it's just like, I just can't take my family, like I explained to Carla, I just can't take my family and just be out the house.
Okay, so go ahead.
It's okay to say something else?
No, go ahead.
And at first, the housing voucher was going good, but then at first they didn't want to deal with the program because they were asking too many questions or whatever the reason. I don't know what the reason was, because the communication should have been between my landlord and my caseworker, Tracy Bundley, but she was not communicating with her due to a disagreement between the two parties, and we were just,
Judge, we were hanging in the balance, basically, between the two. We didn't know half of the information that was being stated from our worker, because she was not coming in, talking with us, giving us information that we needed to have until she wanted us to sign something. That's when she would come and bring us paperwork and we would sign it.
With this worker, where's this worker from?
She's from Rapid Rehousing, the program.
and she just got a promotion.
Well, I don't care about that. What I'm worried about. All right.
Judge, honestly, if I don't have a housing voucher, I'm really.
No, I know. Well,
I
that
have
was,
9 people.
well, that was, listen, I've been doing this work for a while, and that was the one thing that I realized when you guys were on last time. If you don't have a voucher, I don't know how you house 9 people. You want your house back, which would be fine, and maybe a whole lot easier if they have a voucher. Go ahead.
Actually, I don't want to deal with the voucher. That's what she was saying.
No. It doesn't matter whether you want to deal with it. It's where they go. That's what I'm talking about. I'm not talking about you even keeping them. The problem is, in the normal circumstance, what would happen is you'd want them out. They had a voucher. Let's say they just had a family of 3. You have a voucher, then they have to go and they can find a place, basically relocating that voucher and move in. Problem here is I got more people trying to move them and no voucher. Because if what you want, if that voucher was improperly taken in some way, then what you want becomes a whole lot easier to accomplish. Because otherwise what's going to happen is, let's say they don't move, then you're going to be paying to pay somebody to move them out of that house. I don't think you want to do that either. Let me ask you this. Because right now, I'm inclined to give the adjournment to let them investigate it, because this doesn't sound right. The whole thing just doesn't sound right to me. That all of a sudden they say, we're not doing those vouchers anymore. If you had to, how much was rent, the base rent when the voucher was paying? Not, I don't care who was paying it. What do you mean it never was?
He had got accepted for his voucher. We were going through stages of getting the inspection done. And so we can be able to start using, he never got to use his voucher.
So he never was issued a voucher.
He never got to use.
That's a whole different ballgame. So,
I'm sorry, sir. I was issued the voucher based on them doing the inspection of the place. Now, the first time they did the inspection, when Section 8 did the inspection, they counted it as an initial inspection, even though we had already been there.
well, hold on, because you guys now have me confused. There was never, so you never got a Section 8 payment?
No.
She was getting paid through rapid rehousing. They were paying,
Yeah, but they're only gonna pay for a certain period.
And like, the period was up in
February
February this year was their last payment.
was the last payment of the rapid rehousing, because then what should have taken over is you should have gotten their voucher, that should have been in place, and that you should have been doing it.
and sir, that
But
was the reason.
well, no, hold on. So that's where it was confusing in my mind. So you got paid by rapid rehousing, but you never got paid on a voucher.
Never.
Because you weren't issued a voucher.
I was issued a voucher.
He wasn't issued a voucher that really made it a voucher, so they never started paying it off.
You didn't get a payment if they paid in February, you didn't get a payment in March.
Exactly.
Gotcha.
And so, I'm sorry. So Your Honor, what I was trying to tell them as well is, so rapid rehousing, they only let you stay there for 2 years.
Gotcha. Okay. And there's no lease at this point.
And the reason there was no lease because Section 8, the only reason we were given this house due to the amount that we had to pay to move in and due to the high, they usually don't pay this much when it comes to rent, but they did because the voucher was gonna take over.
Right.
That's why there was no lease after last year.
Hold on a moment. So the problem is so what I said before, what makes it easier for the landlord is if you have a voucher. It also makes it easier for you in terms of moving. That's fine if you had a voucher and somebody may have taken it and done something with it, because then it could potentially be reinstated, you could move, they get their house, everything's fine. Problem here is, what I'm hearing is there actually was never a voucher. So you don't really have that voucher to take, like somebody can't come along and say, oh, mistake. You still have your voucher and then move. That's not what this case was, because understanding that now, that's a whole different thing.
We had got a paper in the mail, sir, that said, the time has passed to use your housing vouchers. Like I said in the beginning, she didn't even want to take the program due to whatever was.
Well, she didn't have to take it. I mean,
so when I talked to her, basically, I'm like, this is the house that I need. And I spoke to her, father, as a husband, it's like, this is what I need, whatever I need to do, I'm willing to do it. She was like, okay, we'll take it. And then so we started the process again because they wanted me to find another house rather than a house that I was in. Still.
Okay, just listen. All of that will be fine, except for the fact that the cold-hearted reality in this is you're going to have to move. It just becomes a rougher journey for you because I don't think that voucher, there isn't a voucher. So to understand where my head was at initially, had there been a voucher and somebody says, okay, we're not paying, or we're stopping it for whatever reason, that's not how that would work, where they come along and say, we're not doing that anymore, right? That's not how that would work.
They also took it because on our part, it was turned in on time, but they turned the paper in late when it came to.
Well, I can't go back and do anything with that. The only thing that I can say is there wasn't a voucher. All right. Had they been paid, but they were being paid through a different program. They weren't being paid on the voucher. Had they been paid on the voucher, then I would say, okay, I'm adjourning this out because we got to find out what happened to that thing. And it's going to make it easier on everybody. Right now, this is a circumstance where I don't know that the adjournment is going to do anything because I don't think anybody's going to issue a voucher in 2 weeks.
I just want to give them time to investigate. That's all.
Well, but the investigation isn't gonna. You got paid in February.
She had contacted us, that both of us know, Tracy, that they've been expired for the program. They give you 2 years to sit on this program. And after February was the deadline. So she emailed us in October.
To tell us it would expire. Yes. And then your last payment came in February.
My wife offered her a payment in March. She said, we don't want any partial payment.
They said they didn't want no partial payment.
And we didn't say it was gonna be.
All right,
partial
look,
payment.
okay, I get it.
I had been asking her, what if we could pay the $2,600? Could we stay? Well, I just want to sell the house. Well, if there's a first homeowners program that we could get into, because I said it's gonna be.
Okay, I know, I hear you. And all of that's fine, except that they're gonna be entitled to their property. The real question is how much time is it gonna take you guys to move? And I know, given the circumstances, that's a hard question to even begin to try to answer.
You an answer, because we've been trying to move since.
Okay, let me try from the other end. If I give you a judgment.
As soon as possible. Your Honor, when they came to.
Okay, but look, folks, here's the problem. Do you have the money to pay to move, to have people move them out? Because that's what has to happen.
It's gonna cost me less to have them moved out versus me going, wait months and months. This is costing me, I'm falling deeper and deeper.
You guys are not.
This was my property. I did the proper things to get it back. Did I do the right thing to get my property back? Did I follow the right channels?
But did you say you were gonna understand, because you've been in this position before? Did you just say that to my house, to me and my wife, talk to my kids? Yes,
This
you
is my
did.
first time renting this house out. This is my last.
But,
time.
but
Talking about the being homeless
Folks,
part.
as soon as
you guys can go back and forth, and it doesn't matter.
I understand.
It really doesn't matter. Okay. All right, the cold hard reality is I don't think you understand how much it would cost to empty a house, because all of that stuff is out there. I understand that you're going out of the world backwards. I also understand that if you don't get all of that property out of the house, then that's going to be a problem on you. Okay? You, on your side, don't understand that you're going to have to figure out something.
We're just gonna be homeless again.
Okay,
So we want
and
to
I
program
don't,
homelessness
listen,
come up.
listen. There is not a good answer to any of this. For either side, because you don't want to keep going into the hole financially, right? You got to find a place to put your family. But there isn't an issue for me to should try in the case. The issue is going to be how much time to try to give to not cause more of a burden on the landlord to do what they have to do, and at the same time give you guys an ample opportunity to do what you got to do.
Legally, because when I went down to the court, they told me this was the legal way to do it. And I would have 7 to 10 days. And I feel like in October, this was already on the floor. I feel like this
What do you mean?
when I went to go file, I've been sitting in the courtroom and we've been issuing our writs for 10 days and 7 days. Like, where did my right come in? I don't know the rights to this. That's why I was asking the question. When I went down to file the paperwork, they told me these are the proper channels to do.
I'm not saying that you didn't follow the proper channels. Did I say any of that?
No, that's what I'm asking you. I'm asking you to understand the question.
Well, hold on a second. Did you? Was there a lease? Was there a lease?
Yeah, when we first moved in,
No.
with, February, 18th, 2024. Sorry.
And so when did it expire?
February 2024.
But it says 2025 on the paper.
That's because I never did this before. They told me to put that date at the courthouse.
Who told you to put that date at the courthouse?
Courthouse on Michigan Ave. And I filled out the paperwork. So it's been month to month since last year, February 24th. It's
Okay, so first of all, where's the other notice to quit?
I got some more. Would you like the rest of them?
Well, no, because here's the problem. You keep trying to say that you did everything proper, but now that I'm looking at this, I don't have the notice to quit and how it was served on. The notice to quit to recover property, the very first document, I don't have the one that has the proof of service.
Well, I turned that back into the court along with this receipt.
Ma'am?
Saying that,
Ma'am, I'm looking at the court copy. I'm looking at what you turned into the court. What I'm telling you is I do not have it. When was the notice to quit served?
Yours proof of service, January 28th.
Where's the proof of service? What do you mean January 28th? This isn't the proof of service. This copy that you gave me, right back, that copy doesn't have the proof of service on it either.
When you say proof of service, the proof that the papers were filed or the proof that the papers was given to them?
To prove that you served the notice to quit to recover possession of property.
Yes, yes, they told me to bring back the receipt after the served. This is the,
Let me see what she's holding up there.
this the filing paper.
I don't know what you're holding up. No, that's a receipt. There's a notice of, there's a notice. Here it is, but it's not signed. I don't have a proof of service.
So I took it in.
Ma'am? Ma'am?
I had to prove that it was mailed by the server, by the U.S. Postal Service. That's what you're talking about, the served paper. I had that in the car. It's in my purse.
What was served? Okay, I'm showing, so the record's clear, the notice to quit to recover possession of the property. It has a move-out date of February 28, 2025. It says on here that you certify, this is filled out on the 14th of January, that you served this on Dustin Mickles. Doesn't say you served it on the other party, so I don't know what that's going to do. And you say you served it by first-class mail addressed to that person. Problem is,
because
I don't, what rest of what paperwork?
the rest of the paperwork where I did go down to the courthouse and they put, I had to show them the receipt of the postal service that I had.
This would, yeah, ma'am, I don't know what you're talking about.
What I'm talking about is the papers were served. The papers even get a contact. After I served the papers, I had to go take the courthouse a proof of service with the postal receipt and everything.
I don't know why you would have to take a proof of service on this.
To make sure that it gets served.
That's with the, that's gonna be a different other
Since I had
filing.
Jamie Moore deliver it or have the postal service deliver it, for make sure they got it. That's why they're here today in court, because they got the notice. So I don't understand what's wrong at this point. They got the notice, that's why we're here.
I have to have a proof of service that they had adequate notice. I see that document, but I don't have a proof of service regarding the notice.
Can I go get it right in person?
What's it gonna tell me?
It's gonna take the proof of services that you said you need
For what document?
for the court document paper that we filled out, sir.
Okay, you
That's
filled
why we're
out,
here.
you,
If it wasn't filled out correctly, why are we here?
because everybody would have sent notice out. You have no idea what I'm talking about. The notice to quit, you have shown me a copy of the notice to quit. Pull out your copy of the paperwork.
Can I go get it from the car?
Pull out your copy of the paperwork that you just showed.
What I'm telling you is this paperwork.
You know what? Go out to your car. You just don't listen, and you're gonna go all the way out there. You're gonna come back, and I'm gonna tell you it's not what I'm looking for. But you go ahead, hardhead. You go ahead and do it. You guys have a seat. Court's gonna stand in recess.
State of Michigan is back in session with the Honorable Jason.
Come on up. Recall the case of Green versus Nichols. Parties are present. Ma'am, hand my bailiff what you want to show me. This is what I knew you were going to go out and get. That's not it. Proof of service for summons and complaint. I'm not talking about the proof of service for summons and complaint. Because you weren't listening, you wasted all of our time. I knew you weren't going to bring it to me. The notice is defective. Or you have a document someplace that you did not file with the court. One of the two. In your other paperwork, I see it, but it is not filled out. It doesn't tell me what I would need to tell anyone. The copy that I have in the court file also does not show when the notice to quit was served.
She said it looks like everything is ready to go. And she said
I don't know what lawyer you're talking about.
the lawyer that I ran down, she left out the courtroom. I said, I need my property. I just want to make sure you know that she looked at the paperwork. She said, make sure it's over 10 days. If not, contact me. Because this is new to me too. And it's unfair that I have to go through this.
Ma'am, please don't talk about unfairness. Really, don't talk about unfairness. I've tried for the last half hour to try to tell you what I don't have. You keep trying to pound that square peg into a round hole, telling me, yes, I do have it. I keep trying to tell you that you don't. I keep trying to specifically tell you what you don't have, and you're not listening to me. Then you decide what you want to do is you want to walk all the way out to your car to get it. And I know what you're going to, and you're talking about the Postal Service. I know exactly what you're going to bring back to me, but you keep saying you want to go out there. So I'm going to let you go out there. You walked all the way out there. They sat here and waited. I went back, waited for you to come back. I knew exactly what you were going to show me. And it's not what I'm talking about. So if you want to talk about being unfair, it's that you don't want to listen. You want to try to make something out of something that's not. Time on 2018.
On the 18th, 1 p.m.
Just gonna say this once. If I don't have the proper proof of service on the notice to quit, that is an improper notice to quit. This is a court of statutory, well, these cases are statutory. For me to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. As of this moment, I do not have a proper notice to quit. I think that maybe there is a possibility the defect in the notice to quit can be corrected. I don't know that for sure. I somehow doubt it because you've shown me the blank one and it wasn't filled out properly and not submitted to the court. And so if I don't have a proper notice to quit, the only thing that I can do, since I have not acquired subject matter jurisdiction over the case, would be to dismiss your case. In fairness to you, or to try to be fair to you, if you'll listen, I will give you an opportunity to correct that. If it is not corrected when we get back here on the adjourn day, I will be dismissing the case so that nobody is surprised. If it is corrected, then I will be proceeding with the case. So I'm going to adjourn the matter to April 18th, 2025, 1 p.m., giving you one opportunity to correct the defects in your pleadings. That is all I've got to say. Everybody have a wonderful weekend. Thank you.
Thank you.
Well, best as I can understand things, if they actually get their stuff straight and they get all the paperwork turned in properly, then they begin things from the point of a notice to quit. And if I understand things properly from Michigan tenant laws, which we watch a lot of these, starting from the notice of quit is that first 30 days. You get that 30 days for the notice to quit. Then you move on. Once that is complete, then you get that 10 days for the initial writ if things aren't resolved in that first 30 days. So, ladies and gentlemen, we'll keep an eye on that one. We always watch Simpson. Thank you for coming out, ladies and gentlemen. I'm your Lone Wolf Oozle. I am your host for this here show every weekend where we review some cases from the previous week, and sometimes we have some compilations, kind of like we did today. Thank you all for coming out. I do appreciate everybody for hanging out. Chat's been great today. You all, your contributions add a ton to the videos, and I'll probably cut these videos and drop them the midnight hour sometime later on in the next couple of weeks. So if you want to add some more commentary to those in the comments section, be looking for those to come out, and look out for more videos coming out today, tomorrow, and the rest of the week. And make sure to join us every weeknight for the Fleischer Forum, where we premiere a Fleischer docket and we all sit around and talk about it in a live chat together. Ladies and gentlemen, I appreciate you all very, very much. Thank you for coming out. I'm your Lone Wolf Oozle. I'm your curator for these here videos on the repository we call the Court Gallery. I love you all very much. Y'all have a great weekend. We'll see you next time. I'm Lone Wolf Oozle, and I am out.